Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand.
All right, today we're jumping into a really important topic, Rule 86 of the Rules of Court. This is all about how money claims against a deceased person's estate are handled. You know, it's a super critical procedure because it creates an orderly process to settle debts before the heirs can get their inheritance. Let's break it down.
So, where do we start? Well, our journey begins right at the beginning, with the official starting gun for the entire claims process.
The clock doesn't even start ticking until the court officially appoints someone to manage the estate, an executor or administrator. Once that's done, the court issues a notice that opens up a strict window for creditors to file their claims. And listen to this, it can't be less than 6 months and it can't be more than 12. Then this notice has to be published and posted everywhere, and the executor has to go back to the court and prove they actually did it.
Okay, so that timeline is pretty rigid, and it's driven by the court, not the parties. But here's where it gets interesting. What happens if the court itself gets the timing wrong? Let's look at a classic bar exam-style question to see what I mean.
And the answer is a big yes. The claim is perfectly valid. Here's why. The law is king. Even if a judge's order says 5 months, the law itself sets a mandatory floor of 6 months, so the law basically overrides the court's mistake, which is a huge protection for creditors.
So that 6-month minimum is absolutely non-negotiable, a vital shield for anyone owed money. But now, let's flip the coin. What happens if you're the one who misses the deadline?
This right here, Section 5, is where Rule 86 gets its bite. They call it the Statute of Non-Claims for a reason. It's designed to bring finality to the process so that estates can actually be settled. And the rule is incredibly harsh. If you have a money claim and you don't file it on time, it's gone. Not just paused, not just delayed, it's extinguished, barred forever.
That barred forever rule sounds pretty final, doesn't it? But, you know, the law just loves to carve out exceptions. So let's imagine a scenario where a creditor who missed the deadline might just get a second chance, but in a very specific, almost tactical way.
And believe it or not, the answer is yes. Now, you can't go and file your own case anymore. That ship has sailed. But if the estate turns around and sues you for something else, your barred claim suddenly springs back to life as a defensive tool. It's all about fairness, right? The estate can't demand you pay them while using a technicality to avoid paying you.
So, just remember that a barred claim can't be a sword, but it can absolutely be a shield. It's a fantastic little exception to keep in your back pocket. Now, let's wade into some even more specialized territory.
All right, the type of debt you're dealing with can totally change the game. Let's say the deceased owed a debt jointly with 2 other people. You can only go after the estate for the deceased's 1/3 share. But if it was a solidary obligation, you can claim the entire amount from the estate. It's then up to the estate to chase down the other co-debtors for their shares. Big difference.
Now, what if you're a security creditor, like a bank with a mortgage on a house? You've got options. Section 7 basically gives you 3 strategic paths. You can 1. Abandon your mortgage and just get in line with all the other regular creditors. 2. Foreclose on the house, and if the sale doesn't cover the whole debt, file a claim for the difference. Or 3. Just take the house and walk away, waiving any right to claim more from the estate. It's a real strategic choice.
And the rules don't just apply to creditors. The executor of the estate has a huge duty too. If a creditor files a claim, the executor absolutely must check if the deceased had any claims against that creditor, and they have to raise it as an offset. It's not optional, it's compulsory. It's a classic case of use it or lose it, forever.
That use it or lose it rule for executors is a massive point to remember. Okay, let's follow the claim to the very end of the line, the trial and the judgment.
So you've made it. Your claim was approved, or maybe you even won at trial. The judgment you get will have this very specific wording, payable in due course of administration. Now this isn't just fancy lawyer speak. It's a fundamental concept that limits your power as a creditor.
This is such a critical point. Winning your case doesn't mean you can just go and grab the nearest asset. All it means is that you secured your place in line to get paid when the administrator has the funds and according to the law's priority list. Let's test our understanding with a quick scenario.
And the answer is a firm, unequivocal no. Your judgment simply validates the debt, it doesn't give you a special lien on any property, and it certainly doesn't let you jump the queue and start seizing things. You have to wait for the administration process to play out.
So, a judgment is just your ticket to get in line. It's definitely not a VIP pass to the front. With that key idea in mind, let's tie everything together with a quick summary of the big rules and the common mistakes to watch out for. Think of this table as your ultimate Rule 86 cheat sheet. It's got everything we've talked about: the non-negotiable time window, that absolute bar on late claims, the 3 strategic choices for secured creditors, the compulsory nature of the estate's offsets, and the unique limited power of a final judgment.
And for every one of those rules, there's a trap waiting for the unwary. So here's what to avoid. Don't ever assume a court's shortened deadline is valid. Don't forget that a dead claim can be revived as a counterclaim. Don't try to claim a deficiency unless you did a judicial foreclosure. And if you're the executor, never ever forget to plead your offsets. And finally, don't try to execute a judgment directly on estate property.
Honestly, avoiding those 5 pitfalls is half the battle. At its core, Rule 86 is all about the unforgiving nature of the clock. It's designed to bring cases to a close quickly and efficiently. But this brings up a really deep fundamental question. In its quest for speed and finality, does this rule sometimes sacrifice the genuine right of a creditor to be paid? That's the core tension here, and it's something worth thinking about long after this explainer is over.